Well, thank you very much for this kind invitation. I am especially thankful to Professor Eugenio Buligin from the University of Buenos Aires, to Professor Elena Lisanchuk from the University of St. Petersburg, and also all the authorities from this university for the organization of this wonderful conference in which we have the occasion to discuss issues at the interface between philosophy and international law. The title of my paper is The Irrelevance of Ideal Morality in International Law. So maybe some clarifications are in order. The kind of international law I will speak about is what we might have Westphalian international law. By Westphalian international law, I mean basically the international order that is concerned with relationships among states, among national states. That is the first trait I would like to focus on. So because of this trait, I am ruling out those areas of international law very important today, which are mostly focused on the relationships between individuals, citizens or non-citizens, and national actors, national states, and even non-state actors. The second feature of what I call Westphalian international law is that legal institutions in this kind of international law lack compulsory jurisdiction or compulsory institutions with fact-finding powers. Basically, we don't have in these areas international tribunals which are compulsory in their jurisdiction. And this is, a second very important feature of this kind of Westphalian international law. So, to sum up and to simplify, by Westphalian international law, I understand orthodox or classic international law, and not especially those kinds of international law that have been evolving in the last decades and years. There are two basic theses or views about law in general that I think are very widespread in contemporary legal philosophy. The first view, we might call it, again, I'm doing clarifications first, the normativity thesis or the practical normativity thesis. And this is the idea that law, both national law, domestic law, and international law, is basically a system of practical reasons or a normative system that establishes, for instance, rules of conduct for citizens or other individuals, or provide normative solutions for certain cases that are to be applied by the courts. So, for instance, this idea of law as a normative system is present in this remarkable work written by Professors Eugenio Buligin and Carlos Alchurron, which is entitled precisely Normative Systems. And this is also the idea that authors like Joseph Russ had in mind when they wrote about the concept of a legal system as an order of practical reasons that guide decisions and choices to be made by addressees, by citizens, for instance. The second thesis, or the second view, which I think is very widespread too, is what we might call the idea of the moral legitimacy of law. And this is the thesis that if law is justified, if a certain system of law is justified, then its justification resides in the fact that it is justified or validated by ideal morality. So I do not mean here that necessarily, by definition, law is a morally justified system. My claim is more a conditional one. It is that if a legal system is justified, then the justification derives from ideal morality. And this is a view that many authors, both natural lawyers and positive lawyers, can endorse. For instance, this is a view that Hart endorsed, or the view that, of course, natural lawyers, since Thomas Aquinas in the Middle Ages, have embraced very, very deeply. Now, the concept of ideal morality that appears in my definition of the moral legitimacy thesis requires some clarification too. In general, the basic idea about ideal morality is that ideal morality is a moral code that satisfies certain rational standards. For instance, its rational acceptability, or at least non-rejectability, publicity. This is, for instance, a formal feature that John Rawls in the theory of justice has established very, very strongly. But since Kant's normative investigations, it is also accepted that ideal morality is a kind of moral code that can meet with perfect compliance, that includes those rules that all moral agents alike can apply and respect in their behaviors, even if many agents on many occasions do not respect those rules. In principle, the moral code that we call ideal morality could hypothetically have perfect compliance, perfect respect. And this is the feature that I would like to call practical idealness. Now, the kind of idealness that I am focusing on when I speak about ideal morality is not practical idealness. It is what I would like to call in this presentation epistemic idealness. And by epistemic idealness, I mean the fact that in principle, practical agents or actors who are to apply the rules of ideal morality could possibly have perfect or at least sufficient knowledge about the relevant facts that are included as provisions or antecedents in moral rules, in the moral rules of ideal morality. This brings me to the problem of knowledge and how knowledge is related to the definition of law, of international law, and the relationship between both domestic law and international law on the one hand, and ideal morality on the other hand, understood now not specifically as an ideal practical system, but more as an epistemically ideal system. So my issue is the problem of knowledge in both national law and international law, and this paper is one of a couple of papers in which I investigate this problem. Now, the problem of knowledge has not been very, very widely discussed in contemporary legal philosophy, but there are some remarkable exceptions. And I will draw on three sources, on three different lines, to try to articulate and present my point. These three lines are not really three theories or theses, but mostly insights or ideas or definitions that are useful in constructing my case. The first line is Acheron and Boligin's normative system again. In this wonderful book, Eugenio and Carlos define one interesting idea, that is gaps of knowledge. Unfortunately, this idea is not developed very, very deeply in the book. It is presented, it is shown up as one of the possible gaps that legal systems can cope with. But the central notion of gap is normative gap. So gap of knowledge is more a secondary or an ancillary concept in the whole structure of this magnificent book. They defined in normative systems a gap of knowledge, for instance, on page 33, and I cite, when through ignorance of some of the properties of the fact, we do not know whether a certain individual case belongs to a generic case, we shall speak of a gap of knowledge. And then, many pages later on page 146, they say that the gap of knowledge takes place when there is not enough or sufficient information about some relevant fact. And there is a third definition that is basically along the same line. Now, they suggest that the notion of a gap of knowledge in a normative system is basically a factual notion. And I think that my point can be made by showing that this factual notion is not a necessary condition nor a sufficient condition of what we could fruitfully call a gap of knowledge in any legal system, both domestic or municipal or international law. It is not a sufficient condition because even if we don't have enough information or sufficient information, there might be what I would like to call an epistemic closure rule, which plays a similar role to a normative closure rule with respect to normative gaps. So, for instance, a second-order epistemic rule could say that if a judge or, say, a truth-searching institution within a certain legal system or normative system does not have enough information about a certain property P, then P is false, which means not P is true. So even if we don't have enough information, perhaps we don't have a gap of knowledge if there is a kind of closure, epistemic closure rule, like the one I have exemplified. And it's not a necessary condition either, because even if we do have enough information and sufficient information, it might be the case that there is no public institution or authority who is empowered to express or pronounce the public truth about P. So we are accustomed to systems where we have judges and tribunals who are endowed with fact-finding and truth-ascertaining powers. Authorities that could say P is true on the basis of the proofs of evidence that we have gathered in these proceedings and so on, for instance. But if we don't have those rules that allow some authorities to say P is true, is publicly true, or publicly false, then we still have a gap of knowledge, even if from a scientific or other viewpoint we have enough or sufficient information. So this brings me to the idea that there is one important group of rules in any developed legal system that we might call epistemic rules. Rules that are not practical in the sense that they are not concerned with practical reasons about what to do or not to do, but more importantly, or at least differently, with the fact that sometimes these epistemic rules say an authority has the power to believe P or to ascertain P or to say P is true, publicly true, not from a private viewpoint, not for some parties or some people, but from the viewpoint of the whole community, the whole political community. This is true or this is false with respect, again, to some purposes. For instance, the purpose of condemning someone or showing that he or she is not guilty. Now, epistemic rules, what I call epistemic rules, that are rules that authorize some institutions to ascertain factual propositions, have not been investigated sufficiently. So there is a kind of second order gap of knowledge with respect to gaps of knowledge. So my proposal is to try to fill in this, say, meta gap of knowledge. My second source, or my second line, is well, a different kind of author, Robert Nozick, the American political philosopher, who published in 1974 a very important book called Anarchy, State, and Utopia. And most people, particularly in legal philosophical circles, are familiar with the second part of the book, which tries to show that the state must be limited to respect the moral rights of people. And this is not the part I am interested in now. I am more interested in the first part of this book, which is the justification of the state. And in this very dense and complicated part of the book, Robert Nozick deals with the problem of how to justify the state from the point of view of a moral theory that accepts individual rights. So Nozick follows basically the line of research that John Locke had started in the second treatise many centuries ago. Now, it is very important, very interesting to know that Robert Nozick focuses on the epistemic considerations that are relevant for applying moral theory. So, for instance, he says that the dominant protective agency, which is to become the state, has wide fact-finding powers and the powers to say the truth, the public truth, to punish people and to execute the law on the basis of procedures that are reliable and fair, reliable for the purpose of finding out the truth of the matter in each particular case. And Robert Nozick thinks that the important justification of the state comes from the fact that the state has reliable justice enforcement mechanisms. My third and final line of inspiration, say, is a completely different one. It comes basically from the work of the French historian Michel Foucault and a number of his disciples who have underlined, I think very persuasively and very interestingly, that the modern state starts in the Middle Ages as a political structure capable of applying rational procedures for finding the truth, particularly in criminal matters. In one particular year, 1215, which is a remarkable year in continental Europe, in the Fourth Lateran Council, the Church established that no clergy can take part in ordeals, God's trials of water and hot, or other procedures that rely on, say, magical or non-approved ways for finding out the truth of the matter. Instead of the old Judicium Dei, the Church introduced a new system, a new procedural system, which was to be called Inquisitio or Processus per Inquisitionem, in which the idea of a political agent, a political authority, with the charge or with the commission to investigate the truth of the matter, in particular criminal procedures, for instance through confessions, testimonies, or other forms of acceptable evidence, were introduced. So in that year, a whole process of change took place in which the modern state introduced new institutions for finding out the truth of the matter, with particular officials authorized to express the public truth. And Michel Foucault emphasizes very well that one of the features of the modern state is that it has the capability and the authority to establish the public truth. And this connects very nicely with one deep idea in John Locke's The Second Treatise, in which he says that the political union or the political commonwealth starts when private judgments about the execution of the natural law are replaced with public judgments about factual propositions that are needed to apply certain normative rules. So let me try to draw on these three lines of intellectual, say, inspiration to address again the problem of epistemic rules in national law and in international law. The normativity thesis basically, as I said before, holds that if an international or domestic national law system is justified, it is justified on the basis of ideal morality, of epistemically ideal morality. Well, but it happens that in Westphalian international law, we don't have, by definition, institutions who are allowed by epistemic rules to express the public truth of the matter. Take, for instance, the rules of the war, what international lawyers call jus in bello. As you know, the law of war or the law of just war is divided up in two main branches. Jus ad bellum, which expresses when a nation has a just cause for aggression, and jus in bello, which means the rules that belligerent parties have to respect during war, in warlike scenarios. Jeff McMahon, one philosopher who has written on this problem, thinks that the international law is defective, morally defective, because in equating the position of just combatants and unjust combatants, it doesn't respect ideal morality, because it seems obvious to him that unjust combatants, combatants that do not have a just cause, should not be allowed to kill just combatants, not obviously to kill civilians or other parties. Now, according to jus in bello, all combatants, both just combatants or unjust combatants, have to respect the same rules. Fundamentally, they are two rules, the rules of discrimination. You have to focus your aggression to a legitimate target. And second, you have to, if you have to kill civilians, it must be only in a proportional way as a side effect of an action that is addressed mainly to have a military advantage, and only insofar as the importance of the military advantage is proportional to the number of people, of civilians, that are killed by the aggressive actions. Now, Mamakan says, international law as we have it today does not respect ideal morality, because in ideal morality we cannot put on the same level, on the same equal footing, just combatants and unjust combatants. Just combatants should be allowed to kill, unjust combatants should not be allowed to kill, neither civilians nor other combatants. Now, my point is that this is a mistake, because it doesn't have, it doesn't take into consideration the fact that ideal morality is irrelevant to normative systems which do not include truth-searching and truth-ascertaining institutions. Now, we don't have tribunals, compulsory tribunals, in cases of wars, who could say these combatants are just combatants, other combatants are unjust combatants. We don't have that. So the kind of morality that we should appeal to is not ideal morality, it's not epistemically ideal morality, because epistemic idealness means that we can have knowledge or sufficient knowledge about the relevant factual properties of different cases. Now, when we are in front of normative systems that do not have epistemic rules, and as a consequence of that, do not have institutions which are endowed with powers to settle authoritatively the truth of some propositions that are relevant for applying legal rules, then we have gaps of knowledge in Eugenius and Carlos' definition. Gaps of knowledge are not a contingent feature of these systems, but rather a necessary feature. And it is, I think it should be obvious by now that if we do have necessary gaps of knowledge, because we don't have a developed legal system, a system that includes those truth-ascertaining institutions, then ideal morality is irrelevant, because ideal morality, since Kant's time, is thought of as a system which can have perfect compliance and sufficient or perfect knowledge about the facts of the matter. Let me finish by refreshing some important points made by H.L.A. Hart in the famous book, The Concept of Law. I have 5 minutes still?
Yes, you do.
Yeah? As you know, in The Concept of Law, Hart distinguishes between two kinds of systems: a primitive or stateless system, which is basically a system of positive morality with primary rules, rules of conduct, and then a developed municipal legal system which has incorporated secondary rules that are functional to solving some problems besetting the primitive stateless legal system. Those problems are basically three. The problem of uncertainty, because, I mean, a primitive primary rules legal system is uncertain because we don't have a rule of recognition to identify the rules of the system. So uncertainty is solved by including the rule of recognition. A stateless primitive system is static because it doesn't have rules of change. Hart thinks that a developed legal system includes rules of change. And besides, and finally, a primitive legal system is inefficient because there is no centralized institution for adjudicating disputes and settling conflicts. So Hart thinks that every developed legal system includes rules of adjudication that authorize judges and courts to settle conflicts. Now, inefficiency and rules of adjudication are very vague and obscure terms, in my opinion. Hart fails to identify and to emphasize the role of epistemic rules. Epistemic rules should not be confused with rules of adjudication. They are concerned not basically with the authoritative power to settle a conflict, but with something that is related to that, with the authoritative power to establish the public truth about facts that are relevant. However, Hart makes it clear very well that traditional, or what I have called Westphalian international law, does not have secondary rules. It's a system of primary rules. And he thinks that because international law, in its classic or standard way, does not have secondary rules, change, adjudication, and recognition, international law is not a well-developed legal system. Now, what I would like to say, to sum up my presentation, is that what Herbert Hart should have said in the concept of law is that international law, in its Westphalian traditional variant, is not well developed because it has not included the procedural reform that we have in Western Europe since 1215, a procedural reform that empowers the state with fact-finding powers and to establish and express the public truth. And in the absence of these truth search institutions, we cannot have ideal moral rules positivized as international legal rules. What we have in international humanitarian law is the best possible system we could have in the absence of those institutions. We have rules like those in use in Velo that try to minimize harm, to contain unuseful death, and to prevent civilians from being killed. We have to rely in those realistic contexts in which we do not have judicial institutions on salient features that can be seen very clearly without the need to appeal to very complex or difficult evidence or proofs. So if you have a military uniform, then you are a combatant. If you are a housewife in your house, you are a civilian. Those are salient features. It's very easy to ascertain when someone is a civilian or not. There are some controversial cases, however. But we cannot go into the complexities of ascertaining when a combatant is a just combatant, because whether a cause is a just cause is so complicated in the absence of a third party, a neutral third party that can establish the truth of the matter. We cannot simply have that. So ideal morality, in the sense defined, is completely irrelevant for some areas of international law in which we do not have compulsory jurisdiction with fact-finding powers, and in which gaps of knowledge are a necessary feature rather than a contingent, rare quality. So perhaps we should change also the other thesis about law in general, the thesis about the moral legitimacy of law. If law is legitimate or justified, its justification comes from ideal morality. Now, my view is completely different, and this is the view I plan to defend in a second paper. It is the view that law, as a political institution, law as a normative system enforced by a state, by a political structure, is morally better than morality. Because law has epistemic rules for establishing the public truth. And because of that fact, the kinds of rules that we can afford to have in national normative systems are far superior, morally speaking, than the primitive rules that we had in those times in which we did not have judges or political authorities. So humanity, particularly in Western Europe, has progressed a long time from those primitive systems in which we had stateless primary rules of conduct to more complex, more sophisticated systems, normative systems, legal systems, at which we can regard with legitimate pride because they have made our lives, say, more perfect, morally better than they used to be. Thank you.